All right. Good morning, everybody. And thank you for tuning in to this morning's presentation on campground laws, really a preseason review. My name is Brian Bouchard, and I am an attorney at Sheehan Finney, Bass and Green. And my personal office is in Portsmouth. For today's presentation, here's what we're going to be talking about today. We're going to be talking about RSA 216I. We're going to be talking about the eviction process, what to do with abandoned property, types of provisions you should include in campground agreements with your customers and with your tenants, or not really tenants, but so to speak, tenants, taxes, and municipal compliance. Quick disclaimer before we really get going here. While I am an attorney, this program is designed for educational purposes only and is not a substitute for legal advice of any type. We've slotted an hour for this morning's presentation. I highly doubt we're going to take that long, principally because, as we'll see, RSA 216I is a limited statute. It only does so much. And it only regulates so much. So there's only so much we have to talk about with respect to actual statutory compliance. A little bit about me before we get going. As I said, I'm an attorney at Sheehan Finney. My practice focuses on a few things, but principally it's labor and employment law from a management perspective. But I also do really a copious amount of real estate litigation, land use litigation, and that type, which when you're talking about campgrounds and seasonal permits, it really all comes, those two practice areas come together nicely. I represent a few campgrounds in the state, and this is the time of the year when that campground practice really starts to pick up steam. And so I thought it would be a good idea to just do, a general review of New Hampshire campground law, not only what the law requires, but things campground owners and managers should think about as the season begins to pick up steam here. I am an aficionado of campgrounds. I love campgrounds. I grew up going to Keezer Lake in Lovell, Maine, every summer from when I was 8 to when I was 15. My parents were seasonal campers there, and I have fond memories of riding my bike everywhere, getting into a little too much mischief, and just going up there every weekend. So with that out of the way with, let's get started and talk about RSA 216I. This is your Bible in terms of what you are allowed to do and what you are not allowed to do in terms of operating a campground in New Hampshire. Campground in New Hampshire is a parcel of land on which 2 or more campsites are occupied or intended for temporary occupancy for recreational dwelling purposes only and not for permanent year-round residency. I bolded that last point because it really cannot be understated that if you're going to operate a campground, you need to ensure that no one is taking up year-round residency. But I think more importantly than that, you want to make sure that no one is actually declaring the campground to be their lawful residence. There's a few reasons for that. One, tax concerns. But two, it is far easier to evict somebody under RSA 216I than it is to evict someone who declares a place to be their lawful residence. In that case, you're looking at more of a landlord-tenant relationship, which requires an eviction process be done in accordance with a different statute in New Hampshire, RSA 540, which is more cumbersome, takes more time, and to actually evict somebody, you actually need a court order. For those reasons, you want to ensure that no one is actually declaring residency at the campground. RSA 216, just briefly, before we get into really what I think most people want to hear about, and that's evictions, it does regulate how a campground operates, but only to a limited extent. As you'll see, it's in many ways an incomplete statute, which to some extent, based in New Hampshire, can be to your benefit. So RSA 269 has density requirements. If you're going to have a campsite for tents, it has to be 600 square feet. If you're going to have a campsite for RV units, it has to be 1,000 square feet. Every campground has an obligation to provide potable water. If you are pulling water off a municipal supply or a state supply, that doesn't need to be tested or doesn't need to be approved by NHDES. But if water is being supplied from a private water source, you need approval from NHDES in order to do that. Every campground is also obligated to provide sewage disposal systems in 2 forms. One, you need either flush, chemical, or incinerating toilets on the property, and you need either a sanitation station or individual hookups at each site. The campground's sewage disposal system has to be approved by NHDES, the New Hampshire Department of Environmental Services. I would recommend that every campground have easy access to and keep on file the permits that it obtains from NHDES, both in terms of potable water and in terms of its sewage collection system, just because if it ever becomes an issue, it'd be easy to find. Sorry, just forwarded ahead too much. We're going to talk about registration. I'll put a pin in that one. But there's also a regulation in terms of fire pits. Every campground that wants to have fire pits has to first obtain a fire permit from the town. That's going to be issued from the local fire marshal or fire chief. And of course, there's some regulations that define, what a fire pit can and can't be. It has to be 8 feet across, down 6 inches with sand. You can't have any limbs or trees above it. Things like that. I said it can't be 8 feet across. That's not true. You don't need 8 feet, 8-foot fire pits. Around the fire pit, sort of an 8-foot circumference, it has to be clean to mineral soil. Again, you want to keep that fire pit permit handy in case anyone asks for it. Registration is the one we put a pin in. The New Hampshire law requires that campgrounds register every camper and every guest who stays at the campground. The registration really isn't anything fancy. All you have to do is record the guest, the name of the guest, the name of the camper or the name of the guest. And if the guest is staying with somebody whom they are a guest of. And finally, you have to record the departure time and date. This is important for 2 reasons. One, the law requires it. 2, many ordinances require it. And I guess 3 reasons here. Registration becomes important for facilitating an eviction under one of the statutory options for eviction, which we're going to get to now. So New Hampshire statute has 2 options for evicting people. And I'm going to tell you that while there's 2 statutory options, you can create a 3rd option through your campground agreements. As I said, RSA 216I is in many ways a limited statute, and it doesn't regulate the only way in which you can evict someone. It regulates 2 options, and if you're going to evict pursuant to those options, you have to follow those. But at the same time, the statute is incomplete, as we'll see, and a campground essentially is offering a revocable license to use the campground's property. And as part of offering a revocable license, the campground can revoke that license upon notice to the person using it. So we're going to talk about ways to really build out the eviction process so that you can evict really in an easier fashion in a way that may not fall into these 2 options that are statutory. But for now, let's talk about the statutory options, starting with the first one. So a campground can evict any person remaining in the recreational campground in violation of this chapter. What does that mean? Well, that means anyone who stays longer than their registration. If you have a person who is registered to stay at the campground through May 31st, and they are staying over into June 1st, June 2nd, whatever it is, if it's after the registration date, the campground can simply evict that person. And the process is simple. All you have to do is notify the person that the establishment no longer desires to entertain them. That's language from the statute, and request that they leave. Once you do that, the eviction is done. That notice doesn't have to be in writing. I would recommend that it is in writing. It's always good to have a paper trail if ever there's a litigation situation. Who evicts once you do that? Well, the owner of the campground can do the eviction, an agent of the campground can do the eviction, or a law enforcement officer of the state can facilitate the eviction. Once the eviction is done, the person is evicted. If they refuse to leave the premises, then what you can do is you can call your local law enforcement officer and you can request that that person be arrested. And according to statute anyway, the law enforcement officer is obligated to arrest that person at your request upon a lawful eviction. The second option for a statutory eviction doesn't deal with anyone who is holding over after their registered departure date. It concerns people who are still, lawfully within the premises, but are committing violations that justify them being removed. And there's 2. One is the violation of quiet enjoyment, and the other is a violation of state law. So let's talk about the first one a little bit more. Violation of quiet enjoyment is essentially disorderly conduct, but maybe not arising to a criminal type of disorderly conduct. Although a campground doesn't create a tenant landlord situation in any respect, the right of quiet enjoyment is extrapolated from that. And essentially, in the tenant landlord context, every tenancy has a right to quietly enjoy uh, their leasehold without interference from either the landlord or from anybody else. And it's the landlord's obligation to provide that. So if you have someone who is camping on your premises and is disturbing the rights of others to quietly enjoy what they are leasing from you, although albeit a revocable license, you have the right to evict that person. Also, if they are violating any law, local, state, or federal, you have the right to evict them for that violation of law as well. And those laws are broad. I'm sure you could probably find most offensive conduct to be violative of some law, even old blue laws. The process is a little bit different than if you're evicting somebody because they are staying after the departure date. You have to first attempt to verbally warn the offender that they will be evicted if the transgression continues. Again, the statute just says verbal warning. I would provide both a verbal warning and a written warning if it's all possible. If it's not, someone's doing a night duty, they're touring and they, see someone howling at the moon, a verbal warning is sufficient. Just make sure when that person gets back to the office, they document the verbal warning in some capacity. Who evicts? It's the same type of process as before. The campground, the agent, or a law enforcement officer can evict anybody. I would caution you if someone is disturbing the quiet enjoyment of the campground and they are quite clearly inebriated, or you think that they're inebriated or they're drunk or whatever it is, unable to operate a vehicle. Be careful in evicting them in that circumstance such that they would feel obligated to get into a car and drive. Although you're allowed to evict them, I mean, there could be liability that goes back to the campground based on that eviction. I think if the person is so aggressive that you want them out immediately and not the next day, I would call law enforcement and have that person arrested, and then they can cool it off in the tank. And then the campground doesn't have any issues in terms of evicting someone who is drunk. Talking about option two a little further, because this person was still lawfully within the premises, they haven't used up, they're not holding over after the registration date. According to the statute, they are entitled to the unused portion of their campsite rental or visitor fee, but they have to request it. It's not something that you're obligated to give to them as a matter of course. The evicted person, according to statute, has 30 days to request the unused portion of their fee. And essentially, that's just going to be a pro rata distribution. I would do it by the day. And then the campground is obligated to provide that prorated refund, less any damages caused by the evicted individual. So you can withhold part of it if they do cause damages. I'm going to pause here for a second and just note that if you have questions about any of this, I think we have a Q&A chat going. The way my screen's set up, I can't really see it right now. I have to stop share on the presentation. But if you have questions, put them in there. And then I've built in time at the end for questions. Like I said, I don't think this presentation is going to take the whole hour. But just put them in the chat and I'll do my best to answer any questions you have at the end. So those are the two options for evicting under the statute. I mean, they're limited, right? I mean, what happens if someone, fails to pay? That technically isn't covered by RSA 16. What if there is a violation of the rules and regulations of the campground? What if someone is engaging in just really offensive and impolite behavior, general buffoonery or negligence, violations of your site plan that could cause your site plan to be revoked? All of those things maybe might be tantamount to a breach of quiet enjoyment, maybe not, depending on what they're doing. They might be violative of some state, local, or federal law. It depends on what they're doing. You could argue that failure to pay is equivalent to thievery and larceny, conversion, all these things. But the statute doesn't cleanly address how you evict somebody in those circumstances, particularly for a violation of a rule and regulation. If you have a requirement that people wear helmets while they're riding their bike, and no one does that, that's not really a violation of state law. It's not really a violation of the breach of quiet enjoyment. So how do you enforce those rules for campers other than waiting for the person to leave and then not letting them back? That doesn't really help you in the immediate present. So what I recommend doing, and we're going to talk about this a little bit more, is that when you build out your campground agreements for all customers, and every campground should have an agreement for its customers, you put in a clause for eviction that a person is going to agree to abide by the rules and regulations of the campground, for example. And if they don't, they can be evicted. And you can even spell out what the process is going to be for that eviction. The only thing I would say is that when you're doing that and creating your campground agreement, you can add eviction rights that aren't in the statute, but you cannot take away eviction rights that are in the statute. So what I mean by that is, if you evict somebody for breach of the covenant of quiet enjoyment, you cannot put in your agreement that they are not entitled to a prorated fee or the unused portion of their campground fee. Okay, that's a statutory right that the evicted person has in that context, and by agreement, you cannot undo that right. That's the only caution I would make. So let's talk about abandoned property. I think this is probably the bane of existence for many campgrounds, and it's something that they're just always dealing with. I think from now until October, probably an email a week about what to do with abandoned property, and it's not intuitive, and it's not easy, and it's complicated. So there's two ways to legally dispose of abandoned property in New Hampshire. This being a presentation about the legal requirements under RSA 216 and camping law generally. I'm going to talk about those. So the first is to create a lien for storage and care costs and then sell the property at public auction under RSA 216I. I put sell in quotation marks for a reason you'll find out in a little bit. And the second way is to utilize the unclaimed property statute in New Hampshire, which is RSA 471C. That statute is extremely convoluted and it is slow. Essentially what it says is this, is that all abandoned property in New Hampshire technically belongs to the state of New Hampshire until the owner is located. It doesn't belong to the custodian of the property, okay? What's supposed to happen under that statute is the custodian of the property, whoever just happens to have possession of it, provides an annual report of abandoned property to the state. The state then attempts to track down the owner. And if the owner can't be tracked down, eventually the state will then provide title to the property to the custodian, and that will transfer over to the custodian. The problem is that the problem takes years. Or the process takes years, and it is a problem that does take years. And the campground is left holding the property. If you utilize that statute, the state isn't going to come in and tow away, a 50-foot RV unit and then go store it up in Concord somewhere. It's going to stay on your property until that process unwinds. And if it's staying on your property, then it's taking up campsite, it's taking up storage, and you're limited in how you can operate your business. So fortunately, there is an easier way to deal with abandoned property. It's the way I would recommend that every campground do it, and that is to go through RSA 216. The process looks like this. After an eviction occurs, or the camper departs, without being evicted, and they leave behind property, the campground under statute may move the property off site. You don't have to move the property, but you may. I would use care here, however, although the statute authorizes you to move property off the site. If you damage the property while it is being moved, you still can be liable for any damage caused to the property. The property allows you to move it. Essentially, you're allowed to take this property that is being deemed abandoned and exercise control over it. But it doesn't provide immunity from liability if any damage befalls the property while it's being moved. So just keep that in mind. Use care. Some of my clients actually will hire companies to move the property for them because those companies are insured. And if something happens, then there could be a contribution claim, against that company. Of course, that comes at a cost. So if you decide to move the property, if you don't decide to move the property, it's up to you. Either way, the campground will acquire a lien on the abandoned property for its storage and care of the property. I recommend that you define those costs up front for all campers. I would put it in any notice that you have at the campground. I would certainly put it in your campground agreements that any property that's abandoned, an RV unit, for example, will be moved and stored, and the storage cost is going to be $100 per week, whatever it is. That will then allow you to exercise your rights on the lien. So moving on to the next steps of this, you should then send an invoice of the storage and care fees to the person who owns the property. This is not technically required, but I think it's good practice. In that notice, you can advise the person that if the fees remain unpaid for 60 days, the campground may sell the property at public sale. I would actually advise them that you will sell the property at public sale if the fees remain unpaid and if the property is not claimed. Assuming that the person doesn't come and claim the property or doesn't pay the storage fees that have been accruing for at least 60 days, you then have to provide notice of public sale pursuant to RSA 44 or 444. So those requirements are twofold. First, you have to provide public notice, which is posting of the public sale or really the auction in 2 or more public places in the town that the property is located. So if you have one of those campgrounds that is situated between different towns and the RV unit that you're trying to dispose of that's abandoned is in one of the towns, then the public notices that you have to post have to be in that town and not the other town. So know where your boundary lines are. That becomes important. 2 public notices. And then if the property is worth $100 or more, you're also required to publish notice of the sale in the newspaper. Okay. And if you read RSA 444, there's time restrictions as to when you have to do it. I think it's 14 days before the impending sale. The other type of notice that you're required to provide under that statute is the following. You're required to attempt to obtain owner information and information regarding other lien holders from the DMV, the Secretary of State, or the town clerk. Keep in mind that many people who are using an RV unit often don't own that RV unit. What I've seen is that a lot of times people just leave their RV units at a campground and, allow a friend to come in, and it's already paid for, but the person doesn't want to deal with it anymore. But title never changes to the next person in line. It's still owned by that original person. And even though the person who is using the RV unit and who is paying the campground fee to you, that person may not be the owner. Okay, so it's important to always identify who the actual owner is and at least attempt to do it through going through the processes of the Secretary of State and the DMV. At that same time, you want to identify if there's any lien holders that have liens on the property as well. This could be, really anything from a loan to purchase the property that's being paid back and is secured under Article 9, or it could be a tax lien that's on the property. So you want to identify the owner and any lien holders. If you do identify those people, or you find an owner, if you find a lien holder, then you need to provide direct notice to them by certified mail of the public sale. Okay. Once you've done all that, or actually I should back up. If you go through the process of attempting to find the owner or attempting to find any lien holder, and you don't hear back from the state or the town clerk, or that they are unable to find anyone, then you can presume that there really is no owner and you don't have to provide these direct notices. You still have to provide the public notices, posting in 2 or more places in the town and a publication in the newspaper, but you don't have to directly notify the person. Once you do all that, do all the notice requirements, then you can hold an auction for the property. Most of the time that I've seen, no one actually shows up to bid on the property at all, which is fine. What you can do as a lien holder for your storage fees is you can credit bid on the property for the amount that you're owed. So if the person has accrued $2,000 in storage fees, then you can credit bid up to $2,000. You buy the property for the debt that's owed to you, and then you transfer property of the title through DMV forms. Once the property is in the campground's name, the campground can do whatever it wants to it. It could try and sell it through another third party. It could destroy it. It could do really anything it wants, within the confines of the law. You can't dump it in the river or anything like that. Um, Auction proceeds, again, most of the time that I've dealt with this, the only thing that happens is the campground credit bids for the storage fees that are owed to it. But to the extent there are proceeds, they're going to be paid out as follows. The expenses of the sale are going to be paid out first. That includes any council fees that you incur. Storage costs are going to be paid out next. If there's still money left over, it goes to the lien holders on the property, including tax liens on the town. And then if there's anything left over after that, then it's going to go to the property owners. Now, I will caution you here that between bullet points 2 and 3 in this priority list is unsettled. And there could be possible disagreement between lien holders and the campground as to which entity has priority, the storage fees or the lien holder. Normally, what would happen in an Article 9 context or a tax lien context, the expenses of the sale would be paid out first, if you think about like a typical eviction. Then the secured creditors, the lien holders, would be paid out second, and then sort of the unsecured creditor, the storage fees, would be paid out third, and then the balance to the property owners. However, the way the statute is phrased here, I think leads me to believe that the way I've listed the priority of payouts here is correct, because what it says is after storage fees are paid, the balance to the owner of the property or other person entitled to such balance, which would be a lien holder, including the town, which may have a tax lien on the property. And as I said, most of the time, no one appears at the auction to purchase the property, so campground's credit bid. I think it's helpful, especially as we go into the camping season, for every campground to have a stock eviction notice just on hand that you can modify and change and distribute as necessary. Again, having a good paper trail is a good thing. And this should do the following. It needs to inform the person that they are evicted effective immediately. It needs to inform the person of the reason for the eviction. Again, not required under the statute, but I think is beneficial. Identify the storage rates that are going to be applied to any abandoned property. Establishes the contours of access. What I mean by that is, if you evict somebody for some violation of the law, for example, and they haven't stayed their entire paid term at the campground, obviously you don't want them just coming back on the property, but you do want them to come back so that they can remove their RV unit and take it away, and then you don't have to deal with it. So what I do in my eviction letters is I notify the person that you are required to remove your property by a certain date, and that to re-enter the property, you have to provide 48 hours notice so that you can be accompanied in order to remove your property. That type of thing. That's what I mean by contours of access. And finally, you want to notify the evicted party that their property will be sold at public auction if the storage fees that are going to start accruing remain unpaid for 60 days and are not removed by the time of the public auction. Okay, campground agreements. As I said, every campground should have some type of agreement with its campers, and I think these are the critical terms that you should have in your campground agreement. You could have more, you could have fewer, it depends on the type of situation you have. But first, you want a provision about rules and regulations that every camper is going to agree to abide by the rules and regulations of the campground, that the campground can change those rules and regulations at its sole discretion. And you should also notify in your agreements how those changes will be published or otherwise communicated to campers, such that if there is a violation of them, you can evict the violator. You want to provide for supplemental grounds for eviction. Again, RSA 216 is great. It's a simple process for eviction, but it's limited. So you want to establish contractual rights for eviction as well. And that would likely include any violation of the rules and regulations of the campground. You want to establish payment terms. You want to establish duration of camping season and clearly define that there is a prohibition of off-season occupancy. At the same time, you want a prohibition against residential use. Again, you don't want anyone using the campground for their residence because that has complications in terms of not only taxes, but where they register to vote, but also if you're going to try to evict them they could claim that they are a tenant and they have to go through the tenant landlord eviction process, which is cumbersome. You want to have them maintain insurance on their RV unit, maybe up to a certain amount, up to the value of the unit. You want to provide for indemnity, that they are going to indemnify the campground for any of their conduct, or the conduct of their guests or their minor children. You also want to have waivers of liability. You know, I remember when I was a kid, campgrounds are great. Um, I had a lot of fun as a kid, but I also rode my bike way too fast and probably didn't wear a helmet, enough of the time. So you certainly want to provide for any waiver of liability. Be careful there, though. You can't just say that, the person is going to waive, any liability against the campground for any injuries that may befall them. You need to use specific language, that has been defined by the New Hampshire Supreme Court. Essentially, you have to notify people of every injury that could really possibly happen to them by using the campground premises, and then inform them that, notwithstanding this host of injuries that could happen to you, you're going to agree to waive any liability against the campground, if those injuries do come to pass. So you have to be careful there. Otherwise, your waiver of liability isn't effective, and having one isn't going to help you at all. You want to provide for provisions on site selection, that the campground remains discretion to change sites, as needed. Regulate assignments and sublets of the campground unit, as appropriate. You may prohibit it altogether. That's fine. You just want that stated clear in an agreement. How the campground is going to handle abandoned property, and that the camper is responsible for guests and minor children, not the campground's responsibility at all. Let's round things out with taxes and then municipal compliance. Taxes with campgrounds are complicated. They oscillate between your general real estate tax that is assessed by the town and a motor vehicle registration tax, depending on the RV unit. And this is spelled out in RSA 72(7)(d). Essentially, the way it works is this: certain RV units are exempt from the real estate tax if they have a valid motor vehicle registration, they have a current number plate, and they have a maximum width of 8 feet and 6 inches while being transported, and they're located at a recreational campground. If an RV unit meets those criteria, and again, the registration has to be valid, it has to be current, then they are exempt from a real estate tax, which means that the town cannot tax that individual. Instead, they are taxed through the state vehicle registration process. Campground owners, no matter what, are not responsible for payment of any taxes imposed on RVs located at the campground. So if the town levies a real estate tax because an RV unit doesn't meet the criteria that we just established, the campground is not required to pay it. If a person doesn't pay their vehicle registration tax through the state, then arguably they don't have a valid registration. But either way, the campground is not required to pay it. This is a provision in the statute that I think is the sort of the craw that sticks in the side of many towns. I think towns that I've dealt with kind of have the sense that they provide a lot of services to campgrounds during the season, and that there's minimal tax benefits to the town as a result, in part because some vehicles are exempt. But also, if the town assesses a tax and the person doesn't pay, the town really has limited options in how it recovers that tax, because it can't go after the campground. The most it can really do is levy a lien on the RV unit, which may or may not have value, and the priority of the town's lien may be pretty far down the totem pole. So while campgrounds aren't required to pay any tax or aren't responsible for any tax that's assessed on their campers, the campground does have certain obligations under the statute, and here they are. The campground owners must, before April 1st of each year, this is for seasonal campers, provide the local assessing office with the name and address of each RV owner and identify whether the RV is exempt or not. And the exemption is the criteria that we just talked about. Finally, let's talk about municipal compliance. Campgrounds, in addition to complying with RSA 216, have to comply with municipal ordinances and laws. And it becomes difficult if you have a campground that's situated between different towns or even different states. It creates many obligations to comply with. I think ordinances are the most difficult to comply with because in some respects the town is overreaching, and the town is also one to enforce more requirements than what the state would require through RSA 216. Some of the things that I've seen is a town through its ordinance will limit camping season to certain dates. Sometimes that's March 23rd to October, 1st, I think that's the one in Concord. What the town is essentially trying to do there is prohibit anyone from establishing residency in the town. The towns can limit site occupancy to 6 people per site, or as many that can sleep within the RV unit. If you have, 4 beds, then you can only have 4 people within the RV unit. Establish noise restrictions, regulate density. I've seen one town say that you can only have 1 campsite per acre, which is ludicrous. Prohibit accessory structures, sheds, decks, etc., or at least require permitting for that. And require access for public services, fire lanes and the like, or if there's a gate, then the fire department has to be given a key. Those types of situations. What I recommend here is that you become familiar with your town ordinance. I think all too often campgrounds forget about the town ordinance, which can lead to some uncomfortable conversations with the town when things are not in compliance. Campgrounds must also be mindful of site plan approvals, permits, and property boundaries. And I see this a lot, and it's not that the campground's necessarily doing it. It's you have a person who's been a seasonal camper for 20 years, for example, and every year they just kind of move their site back another foot. They move it back another foot. They move it back. And what happens is either they're violating some screening requirement in the campground's site plan. If they're near a shore, they're violating the Shoreline Protection Act by moving their RV unit, further into the shoreline protection area. Or in some circumstances, they're actually crossing a boundary into another person's property, which becomes problematic. So you want to make sure that you're regulating and keeping an eye on, what I would say, expansion of campsites. But at the same time, a campground cannot just add new campsites either, because the campground, one, is going to be regulated by an ordinance, and 2, there's going to be a site plan approval. So to just add new campsites, you actually most of the time have to go and get new site plan approval, which means going before the planning board of the town. Things to keep in mind, because I think site plan approval or violations of site plan approval are one of the few instances where the town can really assert its authority. And if your site plan approval is revoked because of some unlawful expansion, then you may not be able to operate for the season, which of course would be detrimental. So that is it. If anyone has questions, I see that there's 2 posted in the chat right now, which I can see. I know beforehand, before I get there, someone had written a question in advance about, I saw a few of them about service animals, which I didn't cover in this. And what to do about service animals. I presume that campground doesn't allow dogs or cats or whatever it is, as a matter of course, in the campground, and is frustrated by people coming in and claiming that their dog is a service animal, and what they can do in response. So under the ADA, the Americans with Disabilities Act, any place of public accommodation, which would include campgrounds, is required to accommodate service animals, but they have to be an actual service animal, and most service animals are not. A service animal is something that assists a person with a disability, and they are trained to perform a task associated with that person's disability. So how do you figure that out? Well, there's really 2 questions that you can ask the person. One is your dog, and it has to be a dog. There's only 2 service animals that are recognized by the ADA. One's a dog and one's miniature horses. So you ask the person if their dog is related to a disability. Don't ask what the disability is, but you can ask, is the service they perform related to a disability? And finally, you can ask, what task has the dog been trained to perform? Okay, because again, a service animal is trained to perform a task. An emotional support animal doesn't qualify because that dog doesn't perform a task. It just provides comfort if you're having a bad day or whatever it is. Um, Anxiety attacks can be on the gray line. Essentially, the dog would have to be trained to notify you that you're about ready to have an anxiety attack, or would recognize that you are having one and then would go to you. So it has to be able to perform a job. Um, if those two requirements are met, then you have to allow the dog in. If they are not met, then you don't have an obligation to allow the dog. So with that, let's go to the two other questions. So one person asked, what are the exemptions we need to report to the tax office? The exemption you need to report to the tax office is whether or not the RV unit is exempt from the local real estate tax because of RSA 72.7D. And those are the requirements that I went through a few slides ago. But one, the RV unit has to be validly registered, has to have a current plate number, and it has to have a maximum width of 8 feet and 6 inches while being transported down the highway. So bump outs don't count. That's the exemption that you're reporting, because if the RV unit satisfies those criteria, it cannot be taxed as a local real estate tax. It is instead taxed as a vehicle through the state. Another person asked, if the property, i.e. trailer, is moved off site and into a storage field on the same property, does liability for damage still apply? I think it can and it can't, right? So if the property is moved off site and is into a storage field, something happens in the storage field, the person could claim that, you moved it to an inappropriate location that, caused it damage. And they'd essentially have to prove that it was negligent for you to have selected that field because, I don't know what could happen in an open field. That argument isn't, I don't know how far they're going to get with that argument, in part because if you abandon property, then I think it becomes more difficult to accuse somebody else of wrongdoing. But certainly they would have to show that you breach some standard of care. And I'm not sure that, moving it into a storage location would be a breach of a standard of care. Why do we have to refund money for kicking out unruly campers? Good question. You have to refund money because that's what the statute says. I read the law. I don't make the law. You guys are the ones that are part of an association, and if you want to change it, then you can have the association lobby to change RSA 216I 6. Couple more questions here. If the town has a tax lien on the trailer that has been abandoned and the campground would like to donate it instead of sell it, what is the obligation, if any, to the town? Well, in order to so the campground doesn't have the right to donate the property as a matter of course. What has to happen is you have to go through really the abandoned property process in order to obtain title to the property. Okay, so what would likely happen in that situation is the campground would then have to essentially do a foreclosure on the unit, schedule a public auction, provide notices. The auction would happen. The campground would credit bid up to the amount of the storage costs that have been incurred. And then once that happens, the campground could then say that it purchased the property at auction and then transfer title to it. That process, that legal process, will have the effect of extinguishing any junior liens on the property. So this is what I was going back to before. The town may say that its lien is superior to the campground's lien for storage fees. And I would argue that the way RSA 216I is worded, that the campground's lien for storage fees is superior to the town's lien. So if it is, and the town credit bids on the property for the debt that's owed to it, any prior liens would be extinguished. Which means at that point, once the campground has title to the property, it can do whatever it wants with it. It could donate it and take a tax deduction, but the property would be not encumbered in any way and be free and clear. Another question. So if an RV of any type displays a current registration in any state, it should be reported. Yes. How do you legally / politely deny a service animal if they say no to the two questions? I think what you just say is that, while this dog seems, important to you, It's not a service animal that's protected by law, and unfortunately, we're not going to allow it on the property. I don't think it has to be any more complicated than that. If they have a tizzy about it, then okay, that's their prerogative. But if the dog isn't related to a disability and can't perform a specific job function related to that disability, then they're not protected and they're not a service animal. Uh, I'll note too that many people think that, oh, you have to provide some type of certification for the dog, and that's not the case at all. You don't have to provide any type of certification under the ADA. Someone could train the dog themselves. That's allowed. The other thing to note with service dogs is that the dog does have to remain sort of under control at all times and can't be unruly. So even if you have a service dog that meets the criteria for a service animal under the ADA, but they're barking until 3 a.m, that person can be removed, or the dog can be removed or asked to leave as well. Ron, do or do not report. I'm not sure what that relates to, maybe the prior question. So if an RV unit of any type displays a current registration, it should not be reported. No, it would be reported. If the RV unit is validly registered and has a current plate number and it meets the size criteria, that RV unit is reported to the town so that the town knows not to tax it. What towns often do is at the beginning of the season, they'll come in and they'll provide an instruction in their ordinance. I've seen this, I think Canterbury's or Stratford's ordinance has this, where they say that, if we're unable to tell whether or not your vehicle is exempt from the real estate tax, we're going to tax you, camper. And then it's up to you to tell us otherwise. If a seasonal leaves the campground and removes all of their property from the site without paying taxes due by the town, do those taxes follow that individual, or can they be applied to the next occupant on the site? That's a really complicated question, and I'm not sure there's an answer to it. Generally, tax liens run with the land, such that if I were to go purchase property that's encumbered, I'm going to have to deal with the tax liens that are on that property. Even if the sale, doesn't pay them all off completely. Here, you're really talking about leased land, however. And so I wouldn't think that the taxes would run with the land at all. And certainly the next occupant of the site, if you think about it this way, they could occupy the site with the type of RV unit that would not trigger a real estate tax. So it wouldn't make any sense that a prior tax would then run to the new occupant. You're not going to find a clear answer in the regulations, or you're not going to find a clear answer in the case law about that, because it's never been brought to the New Hampshire Supreme Court, as far as I know. But my position is that the taxes would not run to the next occupant at all, and that would be contrary to the basis of the law. Can a service animal be banned from a rental unit if you do not allow pets in the rental unit? Absolutely not. Banning service animals would be a violation of the ADA, and it's a good way to get yourself sued. What's our recourse with no-shows who get money back through their credit card company? We do not need to. What do we need to state to prevent this? I would have something, within your agreement saying that if you don't provide 48 hours notice of cancellation, that you're responsible for the fee. How do service animals have to be allowed in all areas of the park? For example, we don't allow dogs at the beach if the animal isn't trained to do something that is needed for the animal owner to be. Yeah, so you're not. A service animal is going to be allowed at the beach unless you can make an argument that having a service animal at the beach would unduly burden the campground in some respect. And I think you'd have a tough time doing that. That said, if you have a pool, the service animal is allowed at the pool deck, but you don't have to allow the dog in. That's one of the more brighter lines. How can we charge for damages after balance has been paid? How can we charge for after the balance has been paid? You just charge for them. I think the problem is going to be collecting them. What I would do in that situation is, possibly build it into your campground agreement that if there are any damages that you could then, send a notice of damage or an itemization of damages and then build a credit card that's on file. You might have problems with that. What you could also do is probably do it like hotels do a deposit, $100 deposit, 500, whatever it is, that is then going to be billed to the person ahead of time. They know about it, and then will be returned to them if there are no damages. All right, a couple more questions here. As far as liability, do we need to include any ages in our R&R for helmets, swimming, etc.? You don't need to include ages. I mean, what I would do is certainly notify campers and have them agree that they're responsible for their guests and that they're responsible for their children. But at the same time, I think it would be beneficial to have some type of rule or regulation that says, okay, people can't swim without an adult accompanied if they're, under 10, or, you have to have your parent at the pool, for example, or at the beach, whatever it is. And similarly, if you're under 14, then you have to wear a helmet, and then try and enforce that as best you can. But ultimately it's for the parent to keep an eye on their children, and that parent is going to indemnify you for any harm that happens to their children on their watch, if you structure your campground agreement sort of the way that I've been talking about it. So with that, let's wrap up. I want to thank everyone for coming in this morning. I hope this was helpful to you. The last slide is my contact information. If you have any questions about this, or you want us to represent you, we're happy to do so. Just reach out. And with that, I want to thank everybody again, and have a good camping season.